And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button. And there is a PayPal link down below for anybody who wants to share some love. Always appreciated. And today we are not going to have an open panel. I'm just bringing a video here from last year. It was from the House Judiciary Committee, and somebody brought light of it to my attention, and so I wanted to bring it up and just put it up and let everybody watch, because this is what we're talking about when we are complaining about these courts not operating the way they're supposed to. They're using their administrative powers as if though we are subject to the administration when we're not. So hopefully everybody will enjoy this passage. It's a bit long. It's 2 hours and 18 minutes and 49 seconds. There's a link to it down below for anybody who wants to watch it in their own time. And of course, there's a link to the original presenter, NTD TV. And so we're going to go forth, of course, under the fair use under 17 U.S.C. 107 for non-monetized commentary and discussion for satire, comedy, drama, or even newsworthy entertainment only. So please enjoy, and I can only hope that you will pay attention to what's being said in this meeting, and use it to your advantage by doing your research. Because like I've said many times, don't believe me, don't believe the neighbor, don't believe the government, and for crying out loud, don't believe your mother, and do your research so you know. So again, this is why we are screaming about these administrative law judges and the unlawful activities and the undue duress, threats, and coercion that they're using to fulfill compliance, for filling their pockets, because that's literally what it is. So please pay attention and enjoy the House Judiciary Committee's hearing on reining in the administrative state, the people that pose that they are your daddy under the 10th Amendment and the state's constitution and their administrative statutory codes and this and that. You have to understand, you are not subject to them unless you have a specific contract with them.
Don't mess with Star Trek. Don't mess with Star Trek. The subcommittee will come to order without objection. The chair is authorized to declare recess at any time. We welcome everyone to today's hearing on agency adjudication and other agency action. I will now recognize myself for an opening statement. In today's hearing, we will address how some federal agencies bring enforcement actions against defendants before the agency's own in-house courts. This practice, when federal enforcers sue defendants but bring the case before the agency's own judges instead of before an Article III court, raises a number of concerns. In addition to considering these concerns, we will have the opportunity today to explore ideas for reform. Stepping back, the administration...
My apologies. I was muted there. That's the distinction we're making, is the Article III courts. We the people deserve and require a common law Article III court. These courts, these administrative law judges, are operating under administration of corporations, not the people. That's what an Article I court is. It's operating under the contracts. So if you don't specifically have a contract with the state, then they don't have any jurisdiction because they lack the personal jurisdiction. Again, go back to my last video where we discussed the contracting subject matter and personal jurisdictions. If they don't have personal jurisdiction, then they don't have a contract wherein the subject matter can be applied across the territorial jurisdiction that they pose. Period.
Administrative state is made up of numerous federal agencies. A number of these federal agencies have the power to sue defendants to enforce the law, and the agencies can choose where to sue, in-house or before an Article III judge. There are significant differences between facing an agency in an Article III court and facing the agency's own in-house adjudicator. For example, a number of federal agencies make their own rules of procedure and evidence. These rules can differ from agency to agency, and they differ from the rules used in Article III courts, sometimes in ways that work in the agency's favor. Often, administrative law judges preside over these cases, and unlike Article III judges, administrative law judges are hired and paid by the same agencies that bring the cases before them.
That's an automatic bias. Understand that. It's an automatic bias. They already have a contract, and that contract, they're using their contract against a private man as if though the man is subject to that contract. Damn right, Crispy, I am giving them hell. I've been giving them hell for a long time. I'm the only man I know of that the local court put a protection order out on me saying they don't want me in their courts. They renewed it 5 years in a row. They don't want me speaking my truth in front of everybody in those courts.
Today, we can examine whether these judges are truly independent of the agencies that employ them. Also, unlike in Article III courts, when an agency sues a defendant in an in-house court, the defendant lacks access to a jury, a right the Seventh Amendment protects. Think about that. If the agency...
Understand that. They lack access to a Seventh Amendment court for a suit at common law for an aggregate of $20 or plus $20.
Agency wants to opt for a jury trial, it can, but the defendant, whose rights are at stake, cannot. These and other concerns create a risk of perceived institutional bias that the deck is stacked against the defendants. The risk of perceived bias is made worse by the extraordinarily high number of cases won before their own courts. Because the agency agencies play by their own rules, it is easier for them to get preferred outcomes. Finally, there's arguably a lack of fairness and due process in some of these cases. Defendants are often unable to seek interlocutory appeals on evidentiary and other procedural.
Are you guys not hearing me down there? I'm getting comments, no sound. We can't hear it now. Can you hear me? Can you hear the video? Okay, let's keep going then.
Rulings. The effect is that defendants with limited resources face long odds of success and prolonged and costly challenges from agencies. This imbalance allows agencies to force settlements through exhaustion and can be a way for agencies to avoid judicial oversight from a truly independent adjudicator. To add insult to injury, when defendants settle, some agencies use gag orders to prohibit defendants from discussing their matter critically. There's a serious lack of transparency in administrative adjudication. It undermines confidence in the legitimacy of the proceedings and ultimately in the justice system. Today's witnesses are leading scholars and practitioners with significant knowledge of this subject matter. I look forward to hearing from.
And there's that subject matter. Again, I don't know if you guys heard me earlier. In case you didn't, I referenced the video I did here recently on contracting, subject matter, and personal jurisdiction. And it's relative to this. See, there are certain guidelines that they're supposed to have. And one of those, whenever they're going into court, the prosecuting attorney is supposed to do a pre-investigation. In other words, he's supposed to be checking to make sure that the person that they're bringing into court is a person that is subject to the Article 1 corporate courts, or whether they're supposed to be operating for a Article 3 common law court. If the prosecutor does his job appropriately, and the quote defendant is properly asserting that throughout his life and is recognized in that capacity, rather than being dumbed down and indoctrinated into persons to getting that ID, and understands the distinct difference here, then we can start asserting that common law Article 3 court in its proper capacity. But that is, again, is one of the problems. Not only is the administration operating a Article 1 corporate court against people that aren't subject to it. The people that aren't subject to it don't know this. They don't know those distinctions. They don't know the differences. So therefore, the best they can do is just fall to the whim of these Article 1 corporate courts. And that's what's been going on for decades. That's why they overturned the Chevron doctrine here last year. It's one of those presumptive positions that administrative law judges have taken from that Chevron doctrine that they get to interpret. And therefore, if you don't know, then that means that you will automatically just have to accept their interpretation because you don't know, and you can't put forth the proper violations and stuff.
From our panel of expert witnesses in discussing these important items. I now recognize the ranking member, Mr. Correa, for an opening statement.
Thank you very much, Mr. Chairman, for holding this most important hearing. Today, I think this hearing is about safety. My constituents back home, when they shop at a grocery store, buy prescriptions at a pharmacy, they want to make sure, they want to know that what they're doing is getting something safe. They're buying a safe product. They want to know when they take their children to a playground, to a school, that they're going to be safe, that they won't be playing in a polluted field that might affect their health. And they want to know when they're working that it'll be in a safe environment. And they also want to know that if they want to exercise the right to join a union, that right will be respected. Let's face it, administrative law, most of my constituents won't know what this is, as they shouldn't. That's why they pay us to do the job for them, to keep them safe, to make sure that their families are safe. That's why I'm concerned today by the efforts we see from my friends across the aisle here in Washington to make it harder for these agencies to do their job. Legislation proposed by the majority will leave people in my community and all over America much worse off by paralyzing the very agencies responsible for looking after our food supply, our environment, our free market, our medications, and much, much more. Very soon, the Supreme Court will decide 3 cases, which taken together could tie down our agencies in a new wave of litigation, uncertainty, and ultimately harming ordinary Americans and businesses on Main Street.
And this is where I said the federal government overturned the Chevron doctrine based on those 3 cases. They looked at those cases and they found out, yes, they're overreaching their bounds, even in the corporate case. People, just because they have a corporation and they're running a business doesn't mean that you can go after the people. See, this is why I say if the name and number identify the record, then they're supposed to be going after the record, not the person, not the people. And inherently, that's what they're seeming to find out at the upper levels, amazingly enough.
Mr. Chairman, while some will claim the administrative state threatens free enterprise, let's look at the facts. Today, our economy is stronger than ever. Under President Biden, we've seen very strong economic growth, millions of jobs created, inflation under control, and a thriving economy that is second to none in this world. An economy, a government that are functioning well with.
See, and that's part of the issue right there. Crispy Treat says, well, look at also what's going on with medical marijuana places or just the weed shops. They're legal in the state, but it's not protected by federal. No, because the federal recognizes the sovereignty of the state. The sovereignty of the state says they can contract themselves. And so when they contract, that's what that is. That's a contract. And you have a contract with the state. People still don't recognize the independent value of private contract, and that means with your private man, your private neighbors. And when you deal with a contract with the state, now you're involved with a public contract, and you have to abide by those state codes, laws, statutes, and stuff because it's a corporate entity. If you're just a single man and you have a private contract with your neighbor, that's not a corporate corporate identity. So that's the distinction, is because at the state level, the state poses that private contract authority in its sovereignty, and therefore they get to contract with the private man in their state. But in that's a public contract, contracting to abide by the statutes.
Reasonable regulations. Again, this is about safety. Safety of those back home on Main Street. So I would say, instead of attacking our regulatory agencies, let's help them do the job. Do the job better. Let's give them the resources, the funding they need to carry out the missions, and let them use their expertise that they've acquired over the decades of work.
No, see, that's a distinct difference. Give them the funding. No, they're already taking the funding from the people. That's where they're getting their funding. It's an investment scheme. Okay, so don't listen to this banker. Let me get rid of this banner here real quick. This is Mr. Correa, ranking member. He's a ranking member. He's one of the seniors in this House Judiciary Committee, and he's the one posing that they should fund them more. No, they've already got plenty of funding. That's the problem. They're taking from the people. That's a Fifth Amendment violation.
To do the job, which is protecting our friends and neighbors and people that live on Main Street. That, I would say, will keep our economy moving forward and give our constituents at home peace of mind that they deserve when they think of our government priorities and the job we are doing for them here in Washington, D.C. Mr. Chairman, thank you for calling for this hearing, and I yield back the balance of my time.
Thank you, Mr. Correa. Now recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, today we are gathered not to discuss how the executive branch might work to better protect our air, our water, our food, or our health. Instead, the Republican majority has gathered us to give another platform to far-right advocates who want to dismantle the very agencies charged with protecting our health and safety. Not content to assault our government only in open and violent insurrection, extreme right-wing actors are also launching an assault through our courts to ensure that it is impossible for our government to function. Unfortunately, as we will see today, those two acts of bad faith now go hand in hand. Activists backed by billions of dollars in dark money are bringing cases to our highest court with the purpose of overturning decades of precedent, cases that will create uncertainty for businesses across the nation, that will undermine the protections we rely on for clean air and clean water, and that will enable corporations to evade the law. Based on controversial, novel, and aggressive interpretations of our Constitution, these actors are giving the court the chance to enlarge its power while undermining and limiting those of the people. In one set of cases, relentless and low-bright, they seek to upend decades of precedent holding that courts should respect Congress's authority to delegate to agency experts the careful task of implementing our laws. Instead, they would rather have judges who lack expertise in these often technical matters substitute their own policy judgments in place of those from experts. After a determined campaign to stock the courts with extremists eager to carry out their corporate...
And that's the problem with, like I said, that Chevron doctrine. These administrative law judges overrode the legislative intent and changed it to their intent by reinterpreting it. And that's the distinct difference. That's the unlawful conversion. That's why the federal government overturned it. Said, wait a minute, we somehow made a mistake. Because now that we see it in operation, yeah, that's a definite conversion, and you've been using it to your own benefit. Unjust enrichment, bias, false adjudications, they're all no. Every last one of them is no.
agenda, it's easy to see why. A poor outcome in this case would affect innumerable rules and would undermine the very protections Americans depend on. In another case, P.I.G.S.C.U.N.T.S, the plaintiffs are attacking a system that delivers quick relief from independent judges across the executive branch. A poor outcome in this case would mean that litigants no longer have access to approximately 2,000 administrative law judges, or ALJs, to decide issues ranging from Social Security benefits to securities fraud. If this happens, they'll have to wait many years for the far smaller federal bench, consisting of fewer than half as many judges, to hear their cases. But to those who want to do away with ALJs, the endless delay and the inability of regulatory agencies to enforce the law is a feature, not a bug. Yet another case, Corner Post, seeks to subject regulations to challenge indefinitely, inviting a flood of litigation for years to come.
No, it's not to seek judgment indefinitely. That's what the administrative courts have been doing. They've been, along with the prosecution, they've been pushing them out, extending these things so far out that they expend all of the resources that the people have. That's the theft. Not only do they take the property through fines, fees, penalties, and stuff, but they draw out the litigation so much, and through attorney's fees and all this other stuff, people end up with not a dime in their pocket. They're destroying the country from within. And it's not just them. Like I said, the people have an inherent responsibility to learn this stuff to protect themselves. This has gotten far out of hand. And like I said, when I look at these people like this Nadler guy, I call him a Hitler's willing executioner.
The same forces behind these cases support other radical efforts to undermine regulations that protect Americans' health and safety. In the same term, the Supreme Court is being asked to overturn the FDA's authority and expert judgment in regulating mifepristone, a key tool in ensuring reproductive freedom, to block a national air pollution rule developed by over many years by experts at the EPA that is predicted to save tens of thousands of American lives, and to overturn the considered judgment of the ATF that bump stocks transform semi-automatic weapons into machine guns, capable of discharging hundreds of rounds of lethal ammunition per minute.
And this is again, how do you come up with the interpretation if you're not going back to the original terms of what those weapons are and their intent? Their intent is for protection, right? So it shouldn't matter what kind of weapon you use as long as the intent is for protection. I don't care if a guy is using a slingshot, a dart gun with poison darts. I don't care.
As we saw in the deadly mass shooting in Las Vegas in 2017. These cases are not just an attack on the functioning of our expert agencies, but they're also an attack on the separation of powers, a key pillar of our Constitution.
And understand again, I'm going to point out the video I just did here recently, contracting subject matter and personal jurisdiction. In that, I mentioned the very thing. Let's listen to it again.
Cases are not just an attack on the functioning of our expert agencies, but they're also an attack on the separation of powers.
The separation of powers goes to the identity, and they are misidentifying you as you have misidentified yourself. That ID and driver's license presumes a state employee, part of the administration, and you are allowed resident expense allowances. That's what it's all about. Resident expense allowances. What is resident expense allowance? Remember the video I did on accommodation party and the unambiguous signature? That was the video right before that. And what they're doing is they're violating your right of contract by making a public contract as a presumption because you signed certain government documents without full knowledge. If you had the knowledge to understand that you can't claim to be a resident residing in the zone unless you are a federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board, and it is for income tax purposes, pursuant to state determinations. When you learn how to read, and again, don't believe me, don't believe the neighbor, don't believe the government, don't believe your mother, for crying out loud, do your research. So when you learn to read, so you can then do your research and see what it really says, you'll be amazed. These people have no power anywhere. You have to learn what that person is and how it relates to you and how you can use it. You're the one with the priority use. Anytime you lend that name, it is the lending of credit. You give credence to the instrument or the document, the contract, the agreement, the arrangement. You give credence to it, and it's scriptural. A man is bound by his word. So once you sign the document, you are binding yourself to your word. Do you know the words in the contract? Do you know the subject matter? Do you know the person? Can you distinguish them? If you did, you'd be able to do so in the contract by making sure that it said exactly what you want it to. If it can't, then you don't want nothing to do with it because it would be to your detriment.
A key pillar of our Constitution and the basis for our system of government. They seek to take power away from elected representatives and the officials they charge with carrying out their mandate, and empower judges to completely override the determinations of agency experts, substituting their own judgment, regardless of their comparative lack of technical knowledge and understanding of the underlying subject matter, for the carefully crafted and scientifically based decisions made by agencies. These cases may seem to involve esoteric parts of the law.
Well, let me put something out there to you, Crispy, because if you think I'm crabby, you ain't met me yet. Not everybody wants to read up about that. That's why we watch people like you to let us know, and sometimes we don't watch the videos before this. Well, the problem is, I'm telling you, don't believe me. That's the problem. You keep believing people. You can't know this stuff until you read it and understand it for yourself. I can explain it to you, but I cannot comprehend it for you. Until you get out of that mode, I'm pretty sure most everything in your life will be a failure. And I'm not being crabby about it. I'm being real.
But they have the power to impact every person, every business, and every aspect of our environment. This war on government, this war on our separation of powers will make us all less safe. It will cause serious harm to businesses who will be mired in uncertainty. It will endanger our public health by undermining critical regulations, and it will threaten our economic health by letting large corporations break the law without consequence. This war on government hurts us all.
It's a danger to our democracy. This is dangerous to our democracy. The insanity of these people trying to push this propaganda. Again, I'm not political. Just like I'm not religious. But that doesn't mean I don't have an opinion on it and that I can't express it. Just because I don't follow your religion doesn't mean I don't have an opinion on it if I know what it's about. Just like if I see a bunch of motorcycle riders going down the street and I've never ridden a motorcycle, does that mean I don't have an opinion about it? No. Another flawed thinking process. That's all it is. I hope people learn.
I urge my colleagues to listen closely to what the majority's witnesses say here today. They have not been shy about telling the public exactly what they have planned, and I doubt that there will be any less bold today. They will offer a roadmap for the MAGA majority to continue its assault on the regulatory process and the critical protections that executive agencies provide. If they succeed, the economic prosperity fostered by President Biden's policies will be lost. Right now, the U.S. economy is one of the strongest.
See, now he's forecasting. If they succeed, you can't do that. Okay? You can't do that. And you'll notice a lot of these people, it's one of the things that I use to help me see how they destroy themselves. And it's one of the things I speak about on these platforms. When I'm on these panels and people want to go to these ad hominem character attacks, they've already lost their argument. So when these people start calling each other names, they've already lost their argument.
Strongest in the world. Our rebound from the pandemic is the envy of the world. Unemployment has been at a sustained historic low. Wage growth is outpacing inflation, and consumer sentiment is up. We must not stand idly by while the far right continues its destructive mission. Instead,
I want to point something out. Excuse me, let me get a drink. Okay, so I want to point something out here. He talks about the low unemployment. And the reason it was low is because so many people went out of business, and so then they had to apply for jobs. So not only were businesses closing down, so there was a loss of jobs, it now created a different balance in the employment situation where now there weren't as many jobs that were needed, and there were enough people to fill them. I hope people understand that. It's a manipulation.
Instead, we must act to protect our Constitution, to protect the separation of powers, and to protect the American people. I yield back the balance of my time.
And that's what I'm urging everybody to do in stepping forward and understanding their person and how it relates to them as it relates to the powers that the government has, whether it be federal or state. That's that 10th Amendment, wherein the separation of powers is noted between the state and the federal government, but not the people. And understand the Constitution, the 9th Amendment, is a constitution, or is an amendment in the Constitution that allows us to understand that when that Constitution needs to be amended, the people have a right to redress their government by making those amendments known. It's called public opinion. And we can present to the government the need to change the 10th Amendment in its wording so that there is distinct clarification when it comes to the separation of powers, that the power scheme, the hierarchy of power, is the people, the federal government, and the states. That's an element that most people don't conceive in that because they see the people at the very end in that 10th Amendment.
I thank the ranking member of the full committee. Without objection, all other opening statements will be included in the record. I'll now introduce today's witnesses. Mr. Mark Chenoweth is the president and chief legal officer of the New Civil Liberties Alliance, a nonprofit organization that engages in litigation and advocacy to protect Americans' rights. He's previously worked in private practice and served as chief of staff to then Congressman Mike Pompeo, legal counsel to Commissioner Ann Northrup at the U.S. Product Safety Commission, and as an attorney advisor in the Office of Legal Policy at the Department of Justice. Ms. Jennifer Mascott is an assistant professor of law and co-director of the C. Boyden Gray Center for the Study of the Administrative State.
Pay particular attention to this first guy from the ACLU. It's very important what he says, and he's spot on in my opinion.
At the Antonin Scalia Law School at George Mason University. Professor Mascott has written extensively on administrative law and serves as a public member of the Administrative Conference of the United States. She previously served as the Deputy Assistant Attorney General in the DOJ Office of Legal Counsel. Mr. Robert Alt is the President, Chief Executive Officer, and a member of the Board of Trustees of the Buckeye Institute. The Buckeye Institute is a nonprofit organization that works to advance free market public policy. He previously served as Director of the Center for Legal and Judicial Studies at the Heritage Foundation. Ms. Sky Perryman is the President and Chief Executive Officer of Democracy Forward, a nonprofit organization that works to advance democracy and social justice. She previously served as the Chief Legal Officer and General Counsel of the American College of Obstetricians and Gynecologists and has worked in private practice. We welcome our witnesses and thank them for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. Mr. Chenoweth, you may begin.
Chairman Massey, Ranking Member Correa, and other subcommittee members, thanks for inviting today's testimony. My name is Mark Chenoweth. I'm the President and Chief Legal Officer of the New Civil Liberties Alliance, a nonpartisan nonprofit civil rights organization founded by Columbia Law School professor Philip Hamburger to combat unlawful administrative power.
I'm sorry, I said ACLU. This is Civil Liberties Union. Whether it's ACLU or not, I guess I really don't know, but I would assume it.
NCLA's 14 attorneys pursued more than 50 original litigation cases against unlawful administrative agency actions last year alone, including 2 of them that Chairman Nadler mentioned. This work gives us an up-close, real-world look into the various ways in which administrative adjudication violates Americans' civil liberties. Adjudications, by the way, that enmesh 10 times more people than do federal district courts, so your constituents may actually be familiar with this process. My written testimony compiles a list of 25 pathologies of administrative adjudication for the committee's benefit. Before discussing a few of these, I'd like to highlight the legal mistake behind administrative adjudication. It's typically
the legal mistake behind administrative adjudication. Okay, administrative adjudication. That's the administrative judicial determination. In other words, they're saying that, again, that Chevron doctrine that supposedly gave these administrative law judges the ability to interpret the adjudication or the judicial determination. And they don't have that. The judicial determination is a presumption.
Understood that federal agencies have no power to act unless Congress gives it to them. But the Constitution gives Congress only legislative powers. Congress cannot delegate a power it does not have, so it cannot delegate judicial power. Article 3's vesting of judicial power in the courts is exclusive and mandatory. It says, quote, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish, unquote.
Pay attention. The power, the judicial power was vested in the one Supreme Court and the inferior courts in the state.
By saying the judicial power shall be vested, Article 3 made clear that the location of that power was mandatory.
Article 3. Okay? Understand the distinct difference. Article 3 is where the judicial power sits. Article 1 is where the administrative power sits. They're taking Article 3, judicial power, and mixing it with the administrative power. And that's the legal mistake.
It authorizes Congress to locate judicial power only in inferior courts, not administrative agencies. In setting up administrative tribunals, then Congress has unconstitutionally divested the courts of their judicial power, so it needs to unwind much of this unlawful regime. Apart from these structural constitutional violations, administrative adjudication violates the Fifth Amendment, the Sixth Amendment, and the Seventh Amendment.
And thus, the Article 1 administrative courts are exactly that. They're administrative courts, not judicial courts. And under the judicial administration, they are not allowed to adjudicate the private man, only corporate activities. This is why, if you are going to be represented in those courts, you cannot hire an attorney directly. It must be done through a board of directors, which is a corporate entity.
When I speak of Fifth Amendment violations, I'm chiefly referring to the lack of due process. Agency proceedings scrap the federal rules of civil procedure and the federal rules of evidence, substituting the agency's own rules or making things up as they go. Worse yet, a fundamental...
Substituting agency rules as they go. This is why they don't listen to people in these courts. They've taken this interpretation power in the Chevron doctrine and just gone fucking haywire with it. And it's amazing that the people have let it go on for so long. I was indoctrinated like many, and I saw the problem even in my indoctrination. I don't see why people haven't stood up to this a long time ago.
Tenet of due process is an impartial judge, but ALJs are structurally biased in a pro-agency direction. They're not allowed to question the constitutionality or legality of the laws or regulations they enforce. They routinely shift the burden of proof to the respondent. They are beholden to their agency for their very employment. Unlike the Department of Justice in criminal cases, agencies are also not required to turn over exculpatory evidence to targets of enforcement. So even if the agency has proof of your innocence, it doesn't have to share that with you. Where is the justice in that?
See, that's the difference, another difference with the administrative courts. They don't think they're subject to the oversight. And as long as you don't show that, they're going to keep up with that presumption because they've got you in their grips. If you don't know this stuff, you can't use it against them. Let's listen to that again.
Agency for their very employment. Unlike the Department of Justice in criminal cases, agencies are also not required to turn over exculpatory evidence to targets of enforcement. So even if the agency has proof of your innocence, it doesn't have to share that with you. Where is the...
See, if the administrative agency isn't required to turn evidence over, then where is the oversight? Where is the transparency?
Justice in that. Sometimes the due process violations are even grosser. In early April 2022, SEC disclosed a so-called control deficiency, admitting that its enforcement staff had illegally accessed the files of its in-house judges in NCLA client Michelle Cochran's case, in George Darkessy's case, and eventually in dozens of other cases. As the Wall Street Journal put it, it's the equivalent of a party in litigation having access to a judge's briefs from her law clerks. SEC dismissed 42 pending enforcement cases to dodge accountability for this unbelievable travesty of justice, and Congress needs to get to the bottom of it. But note that this kind of sloppy cross-contamination of functions illustrates the weakening of the
cross-contamination of functions. Okay, it's the function of the judicial branch, which is an Article 3 court, to make those judicial determinations. It is only a function of the administrative court to operate under their administration, which is corporate activities. Nothing more, nothing less. But they're taking their corporate activities and saying that the judicial determination has already been made. You're part of the administration. And that's the falsity. You are not a state, or you are not a federal, state, or municipal officer whose resident presence is deemed necessary by the board. You're not supposed to be a resident in the zone. And the board is the Secretary of Commerce as the executive chair and the Secretary of Treasury. So it is a commercial intent. It is a contract.
The separation of powers when they're combined in a single agency. This could never have happened at the Department of Justice. They don't share the same computer system with the judges. In terms of the Sixth Amendment, one aspect of NCLA client Ray Lucci is administrative.
And that's another problem. How can you have oversight if the federal government, the record-keeping system, doesn't have access to your records? Isn't this supposed to be a centralized government? That's what it's supposed to be. But like I've said many times, it can't be. It can't be a centralized government if the minimum birth registration standards are that the birth must be registered in the United States, and it never is. How can it be centralized if the entire identity documentation origin is never registered properly? That means the identity lies in the state. That is not a centralized government. That is a government of several states of the Union.
Prosecution deserves special mention. Ray Lucci had tried to call his witnesses clients who would testify that they had never been misled or defrauded by him or his use of the term back test. Before they could testify, the SEC served those witnesses with last-minute subpoenas that required them to turn over all their financial records for the last 5 years from any source whatsoever on penalty of perjury. Despite being loyal clients, they didn't want to subject themselves to such an onerous and privacy and security violating task, so they declined to testify.
They declined to testify, and of course they backed out of a lawsuit.
Having withdrawn them from his witness list, Ray proceeded to judgment before his ALJ without a single client witness to speak in his defense. Such witness intimidation would never be countenanced in a real federal court by a real federal judge. Such witness intimidation, in fact, violates the Sixth Amendment, which guarantees the right to have compulsory process for obtaining witnesses in one's favor. But that right to secure witnesses not only doesn't obtain in administrative adjudications as it does in federal court, but apparently witnesses who have agreed to testify can be excluded by agency dirty tricks. The Seventh Amendment is violated because rather than have facts found by a jury, the ALJ finds the facts in an agency proceeding, and the agency controls the administrative record on appeal. So even when a case reaches an Article III court for review, there has never been a jury, and the factual record amassed below gets deferred to by the judge. The Seventh Amendment guarantees the right.
Do you hear that? So even on appeal, it makes it to the higher court without ever having a jury trial. Because it's not a jury trial. It's an administrative tribunal. I hope you guys understand this. This is the twist of the English language. They twist it to their use. Isaiah 54:17. No tongue shall prosper against ye. Ye shall rise up against any judgment. This is the inheritance of the servants of the Lord, and their righteousness is of me, saith the Lord. Learn how to speak.
Right to trial by jury in suits at common law.
Learn those tongues. No tongue shall prosper against you. If no tongue is going to prosper against you, you have to understand the different grammatical changes that they're using to switch all the venues and jurisdictions on you to confuse you.
It thereby applies to all civil actions.
They're very good at it.
Court for review. There has never been a jury, and the factual record amassed below gets deferred to by the judge. The Seventh Amendment guarantees the right to trial by jury in suits at common law. It thereby applies to all civil actions other than in admiralty and equity, including
all civil actions other than equity and admiralty. And equity and admiralty are your venue for correction, declaratory judgment, private bill, private law for the relief of Keith Orland Little, or the relief of whatever your legal name is.
actions brought to enforce statutory rights that are analogous to common law causes of action ordinarily decided in English law courts in the 18th century. Equity involved property and contract claims, not government enforcement, and federal agencies do not sit in admiralty, so agencies routinely violate defendants' Seventh Amendment rights by conducting enforcement proceedings without a jury. For all these reasons, administrative adjudication is an abomination. Justify can be excluded by agency dirty tricks. The Seventh Amendment is violated because rather than have facts found by a jury, the ALJ finds the facts in an agency proceeding, and the agency controls the administrative record on appeal. So even when a case reaches an Article III court for review, there has never been a jury, and the factual record amassed below gets deferred to by the judge. The Seventh Amendment guarantees the right to trial by jury in suits at common law. It thereby applies to all civil actions other than in admiralty and equity, including actions brought to enforce statutory rights that are analogous to common law causes of action ordinarily decided in English law courts in the 18th century. Equity involved property and contract claims, not government enforcement, and federal agencies do not sit in admiralty, so agencies routinely violate defendants' Seventh Amendment rights by conducting enforcement proceedings without a jury. Justify can be excluded by agency dirty tricks. The Seventh Amendment is violated because rather than have facts found by a jury, the ALJ finds the facts in an agency proceeding, and the agency controls the administrative record on appeal. So even when a case reaches an Article III court for review, there has never been a jury, and the factual record amassed below gets deferred to by the judge. The Seventh Amendment guarantees the right to trial by jury in suits at common law. It thereby applies to all civil actions other than in admiralty and equity, including actions brought to enforce statutory rights that are analogous to common law causes of action ordinarily decided in English law courts in the 18th century. Equity involved property and contract claims, not government enforcement, and federal agencies do not sit in admiralty, so agencies routinely violate defendants' Seventh Amendment rights by conducting enforcement proceedings without a jury.
Federal courts do not sit in admiralty, folks. That's where the sovereignty of the state sits. And they use the admiralty, international admiralty law of contracts to ensure their own sovereignty for such places as landlocked states. Without the admiralty in their sovereignty, then they would be absolutely dependent upon the United States. And that's a presumption still. Like I said, this is not a centralized government. If they are not getting all the records from the states of the Union that they're supposed to get in their corporate capacities as a corporate entity, the United States, then it is not a centralized government. It is not a centralized corporation.
For all these reasons, administrative adjudication is an abomination. It supposedly provides expert judges and more efficient proceedings in exchange for the denial of due process protections, but in truth, ALJs are not experts. Administrative tribunals are not efficient, and the denial of due process in agency tribunals with structurally biased umpires is pernicious. Congress has the power to abolish unlawful administrative tribunals and restore the Fifth, Sixth, and Seventh Amendment rights of the people currently subjected to these proceedings. It should do so. Thank you.
Absolutely. Absolutely. It's the Fifth Amendment, the unlawful taking. And I'm going to tell you again, it's the unlawful taking of the intellectual property, which is the grammar. And that's not necessarily a taking in a lot of cases. It's an indoctrination. And you have to overcome that indoctrination and understand the differences. Again, learning what subject matter and personal jurisdictions are and how they apply to these various different implied public contracts.
Thank you, Mr. Chenoweth. Professor Mascott, you may begin.
Good morning. Thank you for having me here today. I will be testifying today in my personal capacity as an academic, and my views do not necessarily represent those of my institution. As the Supreme Court continues this term to review the constitutionality of widespread...
And I have not listened to any of the rest of this, so this is going to be touch and go here. We'll see what comes up.
...agency practices, the scope and proper role of agency adjudication is a critically important topic. Today, in modern practice, agency action touches nearly every aspect of American society. Agency officials make policies impacting religious institutions, schools, small businesses, individuals, and families. These actions and decisions extend into American pocketbooks, financial investments, contracts, healthcare, children's sports teams, and hiring and employment determinations as just a few examples. With all that is at stake, as the members of this committee know, it is essential to ensure that agency procedures implementing these policies are fair and equitable and preserve individual rights and maintain consistency with the federal constitutional separation of powers. It's true, as parties on both sides of the issues agree, that forms of executive branch adjudication have existed since the first year of the first federal Congress in 1789. Adjudication as a broad category involves just applying general rules of law to particular facts. But the early cases of executive adjudication, and in fact adjudication for a significant portion of our nation's history, was much more modest and constrained than adjudication today. and it extended into many fewer and more limited subject matter areas, such as the resolution of internal executive branch disputes and the allocation of government resources. Current administrative practice is substantially and even categorically different. Underlying agency power has ballooned over the past few decades with allocations of significant regulatory, investigative, and adjudicative power blended within single agencies. Agencies and commissions today have substantial power to make policy, to investigate and obtain documents, and then to determine internally within their own tribunals whether violations of those policies have occurred and the civil and monetary punishments that should be imposed for those violations. These adjudicative determinations can amount to what is essentially an exercise of judicial power, at least as that category was understood historically within our American constitutional system. Yet these agency determinations are occurring without the application of many of the individual rights, protections, and procedural mechanisms for fairness, transparency, and accountability that are the hallmarks of what we consider to be just administration of law here in the United States. And that procedurally loose and flexible agency adjudication has the potential to subject individuals and businesses to hundreds of millions of dollars in penalties, to lifetime bars on professional practice, and to years of investigations and litigation. Agency adjudicators often are referred to as judges within the administrative system, yet they are not appointed by the president with Senate consent. They do not have tenure and salary protection, and they are therefore not constitutionally independent. They are appropriately subordinate to the supervision of agency commissioners and cabinet secretaries and the president. This presidential supervision is critical to electoral accountability and to democratic checks, yet that presidential accountability and supervision is anything but complete. The removal of agency adjudicators is subject to Merit Systems Protection Board approval under the current framework. And then there's the deeper question about whether executive adjudicators subject to the political process should be issuing decisions that interrupt American liberty and property interests. Historically, the understanding was no. But today, rather than merely reaching factual determinations or ensuring that parties comply with regulations or give restitution, for wrongdoing, agencies are imposing significant penalties and sanctions that resemble exercises of judicial power. And in doing so, unlike in federal courts, agencies have significant flexibility to create their own procedural rules, giving an even greater home field advantage to those agencies. Further, agencies are often not subject to meaningful congressional guidance about when to bring charges in federal court as opposed to their own tribunals, and agencies are not even required to publish the factors that they rely on when deciding which of those tribunals to choose. Further, agencies or individuals facing agency investigations and adjudication can be under enormous pressure to reach settlements with agencies, which then causes them to waive their rights to any future judicial review. It was not always this way. This term, the Supreme Court is reevaluating whether certain agency actions are currently administered through procedures and instructions that are in tension with the Constitution. But regardless of the outcome of those cases as a constitutional matter, Congress has authority
Damn it. I've been speaking silently. See, the problem is the Article 3 and Article 1 courts and the distinction and differences, something changed. Where did it change? At one time, they knew the difference, and then it changed. And so the difference is they're taking over that judicial function as if though it's part of their administrative duties, and it's not. The people themselves have been dumbed down, and the administrative agencies have been allowed to move forward and continue with their plundering of people's estates through that. And this is the problem. Again, it's not just because these people are corrupt and they'll take advantage of you, but that you don't know how they're taking advantage of you because of the distinct difference between those Article 3 courts and Article 1 courts, and how they apply to persons or people. The separation of powers again.
To act and reconsider whether agency adjudication is now expanded so considerably and so much outside historic procedural norms and rights protections that it should be curbed and regulated much more closely by Congress. Thank you. I look forward to your questions.
Thank you, Professor Mascott. Mr. Alt, you're now recognized for your testimony.
Should be curbed and much more closely regulated by Congress, because at this point it's not regulated by Congress. If they're not required to hand over any records or keep records, then what enforcement is there? This is where they've gone way out of line, beyond their administrative powers, and people have been screaming about it a long time, and this is specifically why they overturned the Chevron doctrine.
Testimony.
Thank you, Chairman Massey, Ranking Member Correa, and members of the subcommittee. Thank you for inviting me here to testify today on this important hearing. My name is Robert Alt, and I'm President and CEO of the Buckeye Institute. Through our legal center, the Buckeye Institute frequently litigates in the field of administrative law. As we began this morning, there were some questions associated with whether or not constituents were familiar with or would be sort of moved by issues of administrative law. So let's break it down to its basics. Everything that I need to know about administrative law, I may not have learned in kindergarten, but one key principle I did learn back then stands out. The one who cuts doesn't also get to do the choosing. Every child understands the separation of functions rule. It's only fair. And yet, contrary to the founders' design, administrative agencies perform legislative functions in making rules, perform executive functions in enforcing the rules, and contrary to the venerable cut versus choose principle, stand as judges in their own cases by means of in-house adjudication. The use of administrative adjudication to decide issues where substantial private rights are at issue raises issues of independence and fairness, particularly where these processes deny rank-and-file citizens of constitutional rights and procedural protections afforded in Article 3 courts. First, administrative law judges who fail to meet the Article 3 constitutional requirements of appointment by the President, confirmation with the advice and consent of the Senate, tenure during good behavior, fixed compensation, and placement in a co-equal branch of government all lack the fundamental characteristic that these requirements were designed to ensure.
Okay. So, let's take a look at that.
Procedural protections afforded in Article 3 courts.
Procedural protections afforded in Article 3 courts. Let's write that down. Procedural.
First, administrative law judges and administrative agencies perform legislative functions in making rules, perform executive functions in enforcing the rules, and procedural protections afforded in Article 3 courts.
Procedural protections afforded in Article 3 courts. 1, 2, 3, 4, 5, I think there was. So let's listen to those again.
First, administrative law judges who fail to meet the Article 3 constitutional requirements of appointment by the President.
Article 3 constitutional requirements. constitutional requirements.
President, confirmation with the advice and consent of the Senate, tenure during good behavior. Senate, tenure during good behavior, fixed compensation, and procedural protections afforded in Article 3 courts. First, administrative law judges who fail to meet the Article 3 constitutional requirements of appointment by the President, confirmation with the advice and
appointment by the President, one, confirmation congressional confirmation,
consent of the Senate, tenure during good behavior.
Senate, tenure of good behavior. Tenure of good behavior is like a apprenticeship or a probation period.
Fixed compensation and placement in a
Fixed compensation. So there's a contract in play.
co-equal branch of government.
And placement in a co-equal branch of government. Co-equal branch of government. Okay, so now we know the requisites for a Article 3 common law judge.
All lack the fundamental characteristic that these requirements were designed to ensure: judicial independence. The constitutional requirements for Article 3 judges are not just empty formalism, but rather these requirements are background rules that together substantively create the conditions necessary for a fair and independent system of adjudication. Issues of judicial independence become even more pronounced when the adjudication is conducted by non-ALJ adjudicators. According to a study by the Administrative Conference of the United States, of the 17 non-ALJ types surveyed that preside over hearings in which their agencies are parties, more than 1/3 have no separation of functions.
So, what we have is an administrative tribunal that is supposed to be a function of administrative law judges that is now delegated unto others that carry on the same function, but yet they're not administrative law judges. This is the same thing as the administrative law judges carrying on judicial functions that aren't theirs. They're now delegating administrative law functions to people that are not qualified as administrative law judges. Profound sense of apparent authority, don't you think?
Which means that the non-ALJ adjudicators may act as judge, investigator, and prosecutor in cases involving their agencies. Whatever hat the non-ALJ adjudicator wears on a particular, the team remains the same, the agency. These non-ALJs are frequently subjected to performance appraisals that the authors of the ACUS study warned, quote, could serve as subtle and not so subtle methods of influencing non-ALJ decision-making, end quote. Or still, many of these adjudicators are eligible for bonus based on factors that further call into question their independence. Unsurprisingly, agency adjudicators are therefore much more likely to rule for agencies. The Wall Street Journal reported that the SEC enjoys—
Is that a surprise? 95% win rate because they rule for the agency. That's their tendency.
a 90% success rate in its own hearings, but only a 69% success rate against defendants in federal court. The New York Times reported simply
90% in one and 20% less, 21% less in the federal courts. And I would urge, or excuse me, I would pose that that number would be much higher if the comprehension was much higher among those defendants. Because if the comprehension is higher amongst the defendant himself, then whoever is making that representation in the court would have a better comprehension and increase that likelihood of winning that case. So again, there's a twofold thing there that's not being considered. Even though there's a 20% reduction in the win rate if they take it to federal court, that still doesn't show that the win rate would be even higher if we had better comprehension as people to assert our Article 3 common law court and its procedures.
Similar statistics finding that the SEC succeeded 92.7% of the time with its internal judges, but only 77% of the time in federal courts. There is an undeniable home court advantage in in-house adjudication. We shouldn't be surprised that individuals who one day serve as an investigator, another serve as a prosecutor, and yet another serve as a judge, and who are reviewed and given bonuses by the very agency for which they are adjudicating claims, would fine for the agency at a higher rate than independent Article 3 judges. The incentives are built into the system itself. The only surprise here is that anyone would defend, in the name of safety, this same process as being a reasonable substitute to an independent Article 3 court. Exacerbating the lack of independent decision makers, defendants in administrative adjudications are deprived of the right to juries under the 7th Amendment. They're deprived of trials which are governed by the federal rules of civil procedure and the rules of evidence, which provide due process protection for defendants, including requirements for hearings, calling witnesses, and discovery.
Exculpatory evidence that would prove innocence, all kinds of things. And this, again, is the problem. These people throw all of that off for their administrative procedure for unjust enrichment for them and their cronies. It's a club, and you're not part of it.
Constitutional requirements for Article 3 judges, in conclusion, are not empty formalities, but ensure the crucial independence of the judiciary in the exercise of judicial power. The usurpation of this authority by the administrative state has led to adjudication by decision makers who lack independence and who therefore rule in favor of their own agencies at rates in keeping with that dependent status. Thank you for the opportunity to testify, and I welcome any questions you may have.
Thank you, Mr. Alt. Ms. Perryman, you're now recognized for your testimony.
Thank you, Mr. Chairman and Mr. Ranking Member, for the opportunity to be here today. My name is Sky Perryman. I am a lawyer and the president and CEO of Democracy Forward Foundation, which is a nonpartisan national legal organization that promotes democracy and progress. Democracy Forward has the privilege of representing clients that make up the very fabric of our democracy across the nation, including organizations of small business owners and entrepreneurs, veterans, doctors, teachers, students, and so many more. Our North Star is a commitment to our country's founding idea that our government should be by, of, and for the people, deriving its power from the consent of the governed. When the government does its job and works for people within the bounds of the law, our society is stronger. And
power of the government comes from the consent of the people. And when that structure is upheld, our country is strong. If it's not, then it's weak. And again, it's because the people are weak in education. If the people are strong in education, knowledge, conscience, comprehension, good faith and fair dealings, this nation is unbeatable. But the people think in their cognitive dissonance that it's wonderful to have the comfort and convenience of such a government until they come knocking on their door.
when the government strays from this purpose, serving only private interests or particularized agendas, our democracy and the well-being of people and communities throughout our nation is in danger. Today, our federal system of democracy.
This is dangerous to our democracy. It's a danger to our democracy.
Democracy, congressional power, and the ability of the government to deliver for the American people and for communities across this nation is threatened by certain litigation in federal courts and by other efforts. More than 6 cases on the current Supreme Court's docket could threaten our government's ability to deliver and do the job for the American people. These cases do involve the work of federal agencies, which are responsible for implementing things like Social Security, Medicaid, small business lending programs, drug and safety protocols, and more. This term, 2 cases, known as Loper, Bright, and Relentless, seek to overturn more than 40 years of legal precedent, known as the Chevron Doctrine.
There you go. seek to overturn 40 years known as the Chevron doctrine, and they did. They finally overturned it in, I think it was September of last year.
And threaten the ability of agencies to effectively implement critical programs that Congress has put in place. Chevron deference recognizes the power of this Congress to delegate to agencies implementation of policies, and that when Congress passes a law that might contain broad or ambiguous or unclear language, that judges should defer to the expertise of federal agencies in implementing that law and not to generalist judges. Overturning Chevron, as the court is being urged to do, could have sweeping implications. Without courts deferring to agency interpretations in appropriate circumstances and to this Congress's intent, there is a concern that courts will substitute their own views for the experience of our federal agencies.
And this, folks, in my opinion only, is why we have DOJ doing what it's doing. And again, I reiterate, I am not political. I've never registered to vote, never voted, but I do have a political opinion based on what I've seen. And what I've seen is every presidency so far has always spoken on the topic of oversight. And it just seems to me that President Trump here is the only one that's willing to go with it and do something about it.
While these cases, and members of the committee mentioned them in opening statements, but while these cases have received some modest attention from media outlets and policymakers, they've received far less attention than they deserve. Characterizations of these issues as concerning, quote, the administrative state often fail to describe the high stakes of these matters to millions of American people.
Absolutely. Absolutely agree. Absolutely agree. I don't understand why the people are not concerned about this. I don't understand why the media is not pushing this. I don't understand why people are not pushing this. And this is something I've been pushing ever since I heard about it, is the overturning of the Chevron doctrine is going to be a step for the people to grasp a hold of and really make an effort to make a difference in their own lives. But again, don't believe me, don't believe the neighbor, don't believe the government, for crying out loud, don't believe your mother. You have to learn how to read so you can then do your research so you know. It's time to quit with the comfort and convenience of letting somebody else do and say everything for you.
Researchers and scholars have warned that everything from our nation's promise to support quality education, to the work that our agencies do to protect the food and medical and drug supplies, to worker and public health protections could be weakened if the court overturns this critical precedent. Among the risk is also regulatory stability, which not only is important for the benefits and the services that federal agencies provide.
Yes, the power of the government comes from the consent of the people alone.
That is also critical for the ability of small businesses and others to grow, thrive, and compete in our economy. In addition to Loper Bright, Relentless, and Corner Post, we are also seeing cases at the Supreme Court that have arisen as a result of the federal government having to appeal orders from the U.S. Court of Appeals from the Fifth Circuit, where that court has adopted positions that not only undermine critical agency functions, but also undermine the way this body, Congress, has chosen to create and structure agencies. As explained in more detail in my written testimony, these cases involve challenges to the structure Congress has chosen in funding the Consumer Financial Protection Bureau, as well as core functions of the SEC and administrative adjudication.
John Locke.
The Fifth Circuit has also issued a ruling at the behest of special interest in Texas that undermines the FDA's scientific and longstanding regulation of an essential medication, a decision that has been opposed by both the medical community and the healthcare industry more broadly. Notably, many of the same interests that are seeking to undermine both healthcare access, including access to the essential medication of mifepristone, are the same interests lodging attacks against the work of other agencies in this Congress. Today, our federal system of democracy and the ability of the federal government to do the work and to deliver for the American people and communities is threatened. Attacks on the ability of our federal agencies to implement policies enacted by this Congress, attacks on the independence of the civil service, and attacks on administrative law judges all could have wide-sweeping negative consequences for the stability and prosperity of our country. The stakes in these matters is high, and
I want you to understand the rhetoric here. This is the Democrat, the Democratic lawyer, and she's calling this an attack against the administrative law judges. Okay? It is not an attack against the administrative law judges. It is an attack against the procedures and functions that they've carried on without the proper authority to do so.
And cannot be ignored. Thank you for having me here today to speak to these issues, and I'll look forward to your questions.
Thank you, Ms. Perriman. We will now proceed under the 5-minute rule with questions. The chair recognizes the gentleman.
Okay, folks. So there's the gist of that video, and like I said, there's a link down below in the details section for anybody that wants to check that out in your own time and watch the whole video. It's 2 hours and 18 minutes long, but I think we covered enough of it to get the general idea of what's going on and the imperative necessity for you to learn how to read and do your research so you can start being active in your own life in enforcing your own rights. Without that, it's always going to be left up to somebody else's interpretation, and you're going to be the one allowing that because you just don't know and you don't have the gumption to know. It's too much work. Okay, that's on you. And with that, we're done for the night. I want to thank everybody for joining me. Please hit that like, share, and subscribe button. There's a PayPal link down below for anybody that would like to share some love. All is appreciated. And you guys know me. I love you. But I don't give a rat's ass whether you love me back or not. That's to say, I don't care if you hate me. I don't care if you don't respect me. That part's on you. So may God bless you and have a good night. We'll see you next time. Bye now.